Breaking news tonight: Supreme Court has just issued an emergency order that's sending shockwaves across America. This isn't your typical ruling, this is an emergency intervention from the highest court in the land, and it's already igniting fierce reactions coast to coast. For millions of gun owners, this decision changes everything overnight. The legal fallout is massive, the political tension is skyrocketing, and both sides of the gun rights debate are on edge. What exactly did the court just do? Why now? And why are both gun rights advocates and gun control supporters in a state of panic? Stay right here, because what's unfolding could mark one of the most consequential Second Amendment moments in modern history. This all started when a lower court upheld a controversial firearms restriction, one that gun rights groups immediately flagged as a blatant violation of the Second Amendment. We're talking about a regulation that targeted specific types of firearms, certain accessories, or imposed requirements that made it nearly impossible for law-abiding citizens to exercise their constitutional right. The restriction had been challenged in federal court, and after months of legal wrangling, briefs being filed, hearings being held, arguments being made on both sides, the lower court sided with the government. They said the restriction was constitutional, that it served a compelling public safety interest, and that gun owners would just have to live with it. But gun rights advocates weren't about to accept that. They knew this was wrong, they knew it violated clear Supreme Court precedent, and they did something that's actually quite rare in the legal world. They requested emergency relief directly from the Supreme Court. They argued that every day this restriction remained in place, constitutional rights were being violated, irreparable harm was being done, and waiting for the normal appeals process would mean months or even years of unconstitutional enforcement. And here's the stunning part: the Supreme Court agreed. The justices moved faster than usual, faster than almost anyone expected, signaling loud and clear that this case couldn't wait for the next term, couldn't sit in a queue while other cases got argued. This was urgent. This was critical. And the court was ready to act. So what did the Supreme Court actually do? Let's be crystal clear about this, because the details matter and the implications are enormous. The court's emergency order temporarily halts enforcement of the firearm restriction nationwide. Read that again: nationwide. This means that for right now, for this moment in time, while the case moves forward through the legal system, gun owners who were affected by this law, who were facing penalties, who were being told they couldn't buy, own, or carry certain firearms, are now protected. The restriction cannot be enforced. Prosecutors cannot bring cases under it. State and federal agencies cannot use it to justify raids, arrests, or confiscations. It's frozen, suspended, put on ice by the highest legal authority in the United States. But here's the bigger story, the one that legal scholars and constitutional experts are already writing about, already analyzing late into the night. The fact that the court intervened at all is incredibly significant. Emergency relief from the Supreme Court is rare. It doesn't happen for every case, not even for most cases. The justices have to be convinced that there's a serious constitutional problem, that the harm is immediate, and that waiting would be intolerable. When the court steps in like this, it's not just issuing a temporary procedural order. It's sending a message. And that message is clear. The Second Amendment isn't up for reinterpretation. It's not something that can be whittled away by clever lawyers and sympathetic lower court judges. The court is taking this seriously, and every legislator, every attorney general, every activist judge needs to pay attention. Now let's talk about how this order came down, because the vote itself tells a story that's just as important as the outcome. The emergency order was issued in a tight 5-4 decision, a split that reveals the deep tension and ideological divide inside the Supreme Court right now. Chief Justice John Roberts joined the conservative majority, aligning with Justices Thomas, Alito, Gorsuch, and Kavanaugh to grant the emergency relief and halt enforcement of the restriction. On the other side, the liberal bloc, Justices Sotomayor, Kagan, Jackson, and Barrett, strongly dissented, arguing that the court should not have intervened, that the lower court's decision should have been allowed to stand, and that granting emergency relief would cause confusion and undermine public safety. This 5-4 split is not just a numerical count of vote. It's a window into the fundamental disagreement about how the Constitution should be read, how much power the government should have, and what the Second Amendment really protects. But here's what matters most. When the court grants emergency relief in a 5-4 decision, especially on a Second Amendment case, it's not hedging. It's not being cautious. It's saying that even with dissent, even with strong disagreement, the majority believes the constitutional violation is serious enough to act immediately. Every time the Supreme Court steps in like this, every time it uses its emergency authority to protect individual rights against government overreach, it sends a powerful symbolic message to the entire country. The Constitution still has guardians, and they're willing to use their power to defend it. Within hours of the Supreme Court's order being released, the Department of Justice reacted, and let me tell you, it wasn't subtle. Officials at the DOJ, speaking both on the record and through carefully worded press releases, expressed what they called deep concern that this decision could limit federal regulatory power and make it harder to enforce what they describe as common-sense gun safety measures. The language was careful, the tone was measured, but the message was unmistakable. The DOJ is not happy about this, and they're going to fight it every step of the way. Now here's where the tone shifts from legal analysis to raw political reality. The DOJ is framing this Supreme Court emergency order as a threat to public safety, as a decision that will put guns in the wrong hands, that will lead to more violence, more tragedy, and more chaos on American streets. But critics, including constitutional scholars, gun rights advocates, and millions of everyday Americans, call it something very different: government overreach being checked by the judiciary, exactly as the founders intended. It's the same pattern we've seen again and again over the past few years. When the Supreme Court defends gun rights, when it reaffirms that the Second Amendment means what it says, the DOJ doubles down. They look for workarounds, they issue new guidance to federal prosecutors, they explore regulatory angles that might survive judicial scrutiny, and they frame every setback as a threat to the American people. But here's the question that gun owners are asking right now, the question that's echoing across social media, in gun stores, in shooting ranges, and in living rooms from coast to coast. Will the DOJ respect this emergency order, or will they find ways to resist it, to undermine it, to continue enforcing restrictions under different legal theories? The answer to that question will define the next chapter of this battle. Blue states immediately started reviewing their own restrictions the moment this emergency order hit the newswires, and some are already preparing emergency legislative measures to counter the court's decision. Governors, attorneys general, and state lawmakers in places like California, New York, New Jersey, Illinois, and Massachusetts are huddling with legal teams, trying to figure out how to preserve as much of their gun control infrastructure as possible without running directly into this Supreme Court order. Some states are talking about rewriting laws to use different language, different justifications, different enforcement mechanisms, all in the hope that they can thread the needle and keep restrictions in place without technically violating the court's ruling. It's a legal chess game, and the stakes couldn't be higher. Meanwhile, on the other side of the country, pro-Second Amendment states are celebrating. Governors and legislators in states like Texas, Florida, Montana, Wyoming, and others are calling this the first big win in what could be a historic legal shift, the beginning of a new era where the federal government and activist state governments can no longer chip away at gun rights with impunity. These states are preparing to expand protections even further, to pass laws that explicitly reject federal overreach, and to create legal sanctuaries for gun owners who just want to exercise their constitutional rights without fear of prosecution. The divide between states is now wider than ever, a chasm that grows deeper with every Supreme Court decision, every new law, every political speech. And this emergency ruling just poured fuel on that fire, accelerating a process that's been building for years. We're watching federalism play out in real time, watching states choose sides, watching the country fracture along ideological and constitutional lines. And it's not slowing down, it's speeding up. Gun rights organizations across the country are calling this a monumental moment, and they're not being quiet about it. Groups like Gun Owners of America, the Firearms Policy Coalition, the Second Amendment Foundation, and yes, even the National Rifle Association, which has been rebuilding after internal struggles, are all issuing statements, holding press conferences, and mobilizing their memberships around this emergency order. One prominent spokesperson said, and I'm quoting here, "The Supreme Court just reminded the government that the Second Amendment means what it says. It's not a suggestion. It's not a guideline. It's the supreme law of the land." That quote has been shared thousands of times, it's being printed on t-shirts, it's being quoted in news articles, and it's resonating with millions of Americans who feel like their rights have been under siege for years. What's striking is the unity across the board. These organizations don't always agree on strategy, they don't always coordinate their messaging, and they certainly compete for members and donations. But on this issue, on this emergency order, they're speaking with one voice. They all agree that this could shape the next decade of legal battles, that this is a turning point, a moment when the momentum shifts decisively in favor of constitutional right. They're already preparing the next wave of lawsuits, already identifying the next set of unconstitutional restrictions to challenge, already planning how to use this emergency order as a precedent, as a blueprint, as a weapon in the courtroom. The legal war over the Second Amendment just entered a new phase, and gun rights leaders are ready to press the advantage. So what happens next? That's the question everyone is asking, from legal scholars to gun owners to politicians trying to figure out how to navigate this new landscape. The case that prompted this emergency order now heads back to the lower courts for full review, for a complete hearing on the merits, for a detailed analysis of whether the restriction is constitutional under the standards set by the Supreme Court in recent landmark decisions like Heller, McDonald, and Bruin. But here's the critical point. This emergency order changes the landscape. It shifts the burden, it signals where the Supreme Court is likely to come down when the case is fully briefed and argued, and it gives gun rights advocates a powerful precedent to cite in other cases across the country. We're already seeing it happen. Other ongoing Second Amendment cases that have been stuck in lower courts waiting for the right moment, are now filing motions for emergency relief, citing this order, arguing that if the Supreme Court was willing to intervene in that case, they should intervene in this one too. It's a domino effect, a cascade of legal challenges that could reshape gun laws in dozens of states and at the federal level. We're entering a critical moment, one of those inflection points in constitutional history where the direction of the law, the scope of our rights, and the limits on government power are all being tested, challenged, and redefined. This is not an exaggeration. This is not hype. One Supreme Court emergency order could define how far the Second Amendment truly goes, and whether the government can continue to chip away at it or whether the Constitution still means what it says. Tonight, the Supreme Court didn't just make a decision, it made a statement. In an era where government agencies seem to grow more powerful every year, where regulations multiply, where bureaucrats claim authority that the founders never intended, the highest court in the land stepped in and said, "Stop. This goes too far." When freedom is tested, when constitutional rights are on the line, America still has guardians willing to stand for them, willing to use the power entrusted to them by the Constitution to check overreach and defend liberty. This emergency order is not just a legal maneuver. It's a reminder that the system the founders designed, with its checks and balances, its separation of powers, its protection of individual rights against government intrusion, still works when we demand that it work. But here's the reality. This battle for your rights is far from over. The DOJ is already strategizing. Blue states are already planning their next move. Anti-gun groups are already fundraising and mobilizing. And the next case, the next challenge, the next constitutional showdown is already on the horizon. If you care about the Second Amendment, if you care about freedom, if you care about whether the Constitution still matters in 21st century America, then you need to subscribe, stay alert, and keep your eye on this channel because we're going to cover every step of this fight. This is history unfolding in real time, and we're witnessing a moment that future generations will study, debate, and remember. The Supreme Court just drew a line. Now we'll see who respects it and who tries to cross it.